This exception, or the EIF, it was created by state courts starting in 1982 to circumvent the Indian Child Welfare Act in cases where a child has an allegedly attenuated relationship with a tribe. And the first time that we see this coming up is in a case called Baby Boy L out of Kansas in 1982. And this was a case involving a child whose parents, according to the court, had really become assimilated into the non-Indian culture, and so really had no intention of raising that child, their child, in that culture. And so the court said, look, we understand in these circumstances, if we were going to follow the Indian Child Welfare Act, that we should be placing this child with a particular family or engaging in a search or taking these extra evidentiary measures in order to ensure the placement of the child within their culture. But the court said, look, it really does not make any sense to do that in a situation where, in the court's determination, the child would not be placed with the kind of a culture that they would have experienced anyway if left with their parents, who, in the court's estimation, again, were not sufficiently Indian to warrant application of the act. As time went on, these cases started coming up more and more often throughout the 1980s and into the 1990s. Really came full circle eventually back in Kansas in 2009, where the court did a careful exploration of the cases that had come up where courts applied the existing Indian family exception and those that had explicitly rejected it, and decided to abandon the doctrine officially. So in 2009, again, the courts come full circle, and Kansas, the first state court to adopt the existing Indian family exception, officially abandoned it. Other states, like Oklahoma, prohibit the application of this existing Indian family exception via statute. So over time, a number of courts, including in Tennessee and others, started to take Kansas's lead in saying, look, we understand that in this particular circumstance, the act should, on paper, apply, but we don't believe that this particular family, based upon the evidence before us, is Indian enough to warrant the application of the act. Other courts, and gradually these courts became the majority, criticized the courts applying the exception and noted, in part, that this was an example of state courts effectively placing themselves right back in the shoes of state courts back in the 1970s and really engaging the same kinds of cultural judgments that the act was designed to prevent and designed to guard against. And as you recall, in the Holyfield case, the Supreme Court case in 1989, the court recognized that one of the most important parts of the act taken as a whole, or that it's inescapable, the court said, not to come away with the notion that the act was designed to curtail state authority. And so the notion that a state court should be placed back in the situation of making a judgment about whether or not tribal parents have attended enough powwows or have close enough relations with tribal members, or whether they have enough of a connection to their reservation ties, or really, quite frankly, are Indian enough, should not be a judgment that a state court applies in order to determine the placement of a child who would otherwise qualify as an Indian child for the purposes of the act. And these courts also focus on the notion that really the Indian Child Welfare Act recognizes a unique